Hello and welcome to Vicarious Liability. This is the AO1, so this is the knowledge, the content that you need for an essay or a scenario question. Do not worry, I'm not going to go up in flames, I hope. Okay, so first of all, there is a difference between whether the tort is intentional or unintentional. Now, I think I've only just figured this out myself, really. I would think of if the person in the scenario does something that is criminal, so abuses someone, sexually assaults someone, punches someone in the face, that is what we call an intentional tort. So we'll come on to that. So in my mind, I think, right, what is it? Is it intentional or is it unintentional? Now, if it's an unintentional tort, you follow the traditional tests, which was set out in the case of Salmond. First of all, the control test. How much control does the employer have over the employee? Case example, Hawley, this was the bouncer from a firm. He worked at the club, assaulted a customer. Now the suppliers of the bouncer went bust. The club was liable because they did exercise a lot of control. So if you exercise control over the person, then they are likely to be seen to be an employee. The second traditional test, if it's an unintentional tort, is the integration test. So how much is the person a part of the business? And the more that they are kind of involved in the business, the more likely they are to be seen to be employed, and therefore the employer is responsible. The third test is the economic test. So I would be looking at clues like, are they being paid? Do they pay their own national insurance? Do they work their own hours? So when it looks like employment, it probably is employment. So I'd be thinking, right, they get paid by the company, they're probably employed, or they set their own hours, they're probably self-employed. You then, with the traditional tests, have to look at whether the tort was committed in the course of employment. So if it was, then the employer is vicariously liable. Acting against orders. The case of Limpus, the employer told the bus drivers to not race each other. They did, there was an accident, and the employer was responsible. When the employee commits a negligent act, so Century Insurance, he threw a match down at a petrol station. What a clown. And there was an explosion. So even though he was negligent, the employer was still responsible. And then finally, acting on a frolic of your own. If you act on a frolic of your own, you do something completely unforeseeable, then the employer is unlikely to be responsible. So that is the case of Hilton. They took an unauthorized break. So, and if the person is an independent contractor, then the employer is not responsible. Now, if the tort is intentional, this is the important thing to distinguish. If it's intentional, so they punch someone, they commit a crime, the doctor in Barclays Bank sexually assaulting people, these were intentional torts. So two tests, dead straightforward. Is it akin to employment? And does it pass the close connection test? So is it akin to employment? Does it look like employment? Case of Barclays Bank is very useful here. This is where the claimants brought an action against the doctor who was doing medicals on behalf of Barclays when they joined the bank. Doctor was assaulting people. Now, the doctor was deemed by the Supreme Court to not be an employee of the bank. The doctor was an independent contractor. Lady Hale tried to clarify matters and said, if you're unsure whether it is akin to employment, you have to go through the 5 stages in the Catholic Child Welfare Society case. Now, these 5 criteria are quite difficult to remember all 5, but as long as you get the kind of sentence, it doesn't have to be word for word, is what I'm trying to say. So first of all, number 1, the employer is more likely to have the means to compensate the victim than the employee, and they may well have insurance. Number 2, the tort will have been committed as a result of activity being taken by the employee on behalf of the employer. Number 3, the employee's activity is part of the business activity of the employer. Number 4, the employer, by employing the employee to carry out the activity, created the risk of the act being committed. And number 5, the employee will to a greater or lesser degree have been under the control of the employer. So you might want to like re-listen to those and summarize them in your own words. But essentially, if you don't know whether it's akin to employment, use these 5 stages. So in a scenario question, go through each of the 5 and apply it to what you've got in front of you. Then the second test is the close connection test. Well, what is this? Was the employee's wrongful conduct so closely connected with the acts they were authorised to do that it was done whilst acting in the course of employment? So Morrison's, the employee assaulted the customer, causing him serious injuries. The Supreme Court said it happened at work, and therefore there was a close connection. So go back, re-listen to this, think, is it an intentional tort? Has the person basically committed a crime? If it's an intentional tort, akin to employment, close connection test. If it's an unintentional tort, you use the traditional Salmond tests. I hope this helps. I think I've finally got it clear myself. Law is difficult, but if you just stick with it, try and summarise it, ask me any questions, and good luck.